Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and in today's episode of Polity Primer, we are going to discuss an interesting and important topic. This topic becomes even more important as elections are just around the corner. The title of our today's discussion is Criminalization of Politics. In this discussion, we are going to study about what is criminalization of politics, the statistics in this regard, the legal aspect of disqualification of criminal candidates. We are also going to see some of the initiatives and recommendations in this regard, and we are also going to analyze what the Supreme Court has observed in this regard. And in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, recently the Supreme Court in a case has rebuked the Parliament regarding pendency of criminal cases against the MPs and the MLAs. The Supreme Court has specifically asked the Parliament that why are they not following the speedy justice? Why are they not following speedy investigations against the pending criminal cases of the MPs and the MLAs? So this brings us to the moot question of our today's discussion, that what is criminalization of politics? If I explain this to you in very layman terms, it means that those candidates are entering the politics, or those candidates are getting selected who have criminal antecedents against them, who have pending criminal cases against them. And the Supreme Court has cautioned that the element of criminality from politics should be removed. So, criminalization of politics is defined as the situation when criminals participate in the politics of the government and they contest elections and get elected to the parliament and state legislatures. So this is a death blow to our democracy. We should not encourage this practice, and we should definitely be aware about the criminal antecedents of the candidates that we are choosing to vote. Okay, so this growing menace has become a big problem for our society, affecting the basic principles of democracy such as fairness in elections, following the law and being accountable. If they have pending criminal cases against them, do you think they are going to be accountable to you? I don't think so. Let me know your opinion in the comment box below. Okay. So if I talk about the statistics in this regard, the statistics of having those MPs and MLAs which have pending criminal cases against them, the figures are very shocking in nature. According to the data from ADR, ADR is the election watchdog that has been formed by the professors of IIM Ahmedabad, and ADR is time and again approaching the Supreme Court regarding the violation of its judgment, and ADR is saying that the political parties are not following your observations. We will study about the observations of Supreme Court in our further slides. So this ADR, the number of candidates with criminal charges elected to parliament in India has been on the rise since 2004. So in 2004, 24% of the parliamentarians had pending criminal cases, which rose to 43% in the 2019. And if you talk about the current parliament, then 50% of legislators have pending criminal cases against them, and some are very serious in nature that can be punishable up to death penalty and life imprisonment. So just imagine that these people are sitting in the current Lok Sabha as well. Okay, so in a petition filed in February 2023, it was claimed that there has been an increase of 44% in the number of MPs with declared criminal cases since 2009, and this is a very alarming trend that is happening in our country. These statistics show us the shocking figures that how are we selecting our candidates and the deep-rooted criminality in the politics. Okay. So now let us analyze the legal aspects of disqualification of the criminal candidates. So if I talk about the Constitution of India, our Constitution of India does not have any provision that disqualifies a candidate if he has some criminal antecedent or if he has some pending criminal cases against them. So the Representation of People's Act 1951 mentions the criteria for disqualifying a person for contesting an election of the legislature on the ground of a criminal antecedent against them, and the section here is section 8. So section 8 of the RPA 1951 talks about disqualifying those candidates who have been convicted. The word here is convicted for an offense that carries a jail term of 2 years or more. So they cannot contest election 6 years after they have been convicted for an offense, the punishment for which is 2 years or more. So this does talks about the barring of those candidates which have been convicted. But the RPA is also silent about those candidates who have pending cases against them. Tendency is different, and conviction is different. Conviction is the end result, but what about pendency? We are still accepting those candidates as our candidates for elections, and they are getting freely elected as our MPs and MLAs. Okay, so the Law Commission in its 179th report recommended an amendment to the Representation of the People Act 1951. It suggested that people with criminal background should be disqualified for 5 years or until acquitted. So obviously this recommendation was not followed. The Law Commission also suggested that you should declare the number of FIRs that have been filed against you. But definitely these recommendations were not followed by the government. Now let us analyze the initiatives and recommendations in this regard. So if I talk about the first initiative that has been taken, so it was taken in the year 1983. So the Vohra Committee on Criminalization of Politics was constituted with an objective to identify the extent of political criminal nexus and to recommend ways in which the criminalization of politics can be effectively dealt with. All dead letters. Nothing has happened. As you might have figured out from the discussion as well, that nothing till date has happened. Okay, so all these are dead letters, and we are just discussing them, that yes, efforts have been taken, but they have fallen on deaf ears. Okay, so the 244th report 2014 submitted by the Law Commission, again 179th report, they also recommended an amendment to the RPA Act. We have studied this in our previous slides, and the 244th recommendation report by the Law Commission also suggests that we need to curb the trend of criminal politicians in the legislature, posing serious consequences to the democracy and secularism. But what is happening? Nothing is happening. And if you ask me, ma'am, what is the reason that we are electing criminals as our legislators? So first is the vote bank politics. No party wants to compromise on its vote bank. And what happens is, if you pitch a clean candidate and if you pitch a corrupted candidate, the winning probability of corrupted candidate will be higher than the clean candidate. So this is what is happening. Then there is corruption, there is lack of governance, there is contempt of law. Even the model code of conduct, as we have discussed, is not legally enforceable. So all of this is adding up to the winning probability, and the political parties, almost all of the political parties have this tendency that they select candidates, those who have criminal antecedents, because they are very powerful in nature, and definitely they in turn increase their winning probability. So why to lose the elections, rather to give ticket to those candidates? So this is what is currently happening, and the reasons are vote bank politics, corruption, and definitely the lack of governance and lack of strict laws that can provide a relief from this menace. Okay, so the Law Commission recommended disqualification of people against whom charges have been framed at least 1 year before the date of scrutiny of nominations for an offence punishable with a sentence of 5 years or more. In 2017 also, the Union government started a scheme to establish 12 special courts for a year to fast track the trial of criminal cases against MPs and MLAs. But all of these are dead letters. These 12 fast track courts have not been established. They have been started, but they are doing nothing. No effective investigation is there, and no speedy justice is there, and that is why the Supreme Court is proactively intervening in the matter and has currently rebuked the Parliament in this regard. So if I talk about the Supreme Court's observations on criminality of politics, then the SC removed the statutory protection of convicted legislators from immediate disqualification in 2013, and in 2014 directed the completion of trials involving elected representatives within a year. So the Supreme Court, as I have stated before also, is playing a very proactive role in this regard. And time and again, it questions the parliament. Okay. So in 2017 also, it asked the center to frame a scheme to appoint special courts to exclusively try cases against politicians and for political parties to publicize pending criminal cases faced by their candidates in 2018. But what happens is how the political parties are flouting these directions. Let me explain to you. So what they are doing, they do not have a functional website. Okay. So, and secondly, like they say that why should we discourage our candidates? They are not yet convicted. So how can you say that they will be convicted? So the law favors the innocent rather than the guilty. So as long as they are not convicted, they are considered to be innocent. And this is why the political party states that they, due to revenge or due to personal enmity, these cases have been filed against them. And why should we prevent them from contesting the elections if they are not proven guilty? So this is how the political parties are flouting the Supreme Court observations or guidelines in this regard. Okay. Then in 2019, what happened was the Supreme Court has ordered political parties to publish the criminal records of their candidates on their websites, social media handles, and newspapers. So this is also dead letter. No political party is following this initiative or the guideline of the Supreme Court. And this fact itself was acknowledged by the Supreme Court in the 2020 case. So this judgment, which came in 2019-2020, a contempt petition was filed in the Supreme Court that, look, no political party is following your guideline. Kindly do something, kindly take an action. So the Supreme Court in 2020 also said that the parliament should comply with its 2018 judgment. The court also directed the Election Commission of India to create a framework to ensure that the information of candidates' criminal records were disseminated effectively. But even if it's disseminated, I don't think so this will bring a change. The people, they will vote for those people who are famous or who work for them. And if you have power, you can work for the people. You can be because with power comes money, and with money comes a lot of again power. So this power helps us to the candidates to actually work for the people, and people votes on these lines. So even if we will try to find out the criminal antecedents of a candidate, this will definitely not reduce their winning probability. We need more reforms in this regard. We need to spread more awareness in this regard. Okay. So this image shows the Supreme Court crackdown on criminalization of politics. So the Supreme Court took up the issue of criminalization in Indian politics in two separate cases, and these are the key takeaways. So cases against politicians, state governments cannot withdraw criminal cases against legislators without permission by the High Court, and this has been ruled by the Supreme Court in a very recent case. The parties punished. 9 parties including the BJP, Congress, JDU and RJD held guilty of contempt of incomplete disclosure on candidates ahead of 2020 Bihar elections. 8 of them have been fined. And a special bench at SC may be formed to monitor the cases involving accused MPs and MLAs, the apex court has indicated. So the Supreme Court is talking about taking all of these proactive steps that can be, to reduce the criminality of politics. And the Supreme Court is very serious in this regard. The Supreme Court has also asked the Election Commission of India to come up with a mobile app on which it will clearly show the criminal antecedents of the candidates. Let us see which of these steps are getting implemented in the long run, but let us see what happens. These are the observations of the Supreme Court in a very recent case, because Supreme Court is very serious about removing criminal elements from politics. So with this, we come to a conclusion of our today's discussion. We have seen what is criminalization of politics. We have also seen that our Constitution of India does not mention having criminal cases or having pending criminal cases as a ground for disqualification. The RPA does, or the Representation of the People Act does mention this ground in Section 8, But what is the flaw? That it talks about conviction and it does not talk about pending cases. So this is a flaw of the RPA also. And we have also seen the initiatives, recommendations and the Supreme Court observations in this regard. So time will only tell that how effectively we can remove criminal element from politics. As my suggestion or my personal suggestion is, just be careful for whom you are voting. Exercise of your right to vote, smartly can help you elect a candidate which will actually work for you. So kindly be careful while exercising your right to vote. Now let us see a practice question for your prelims examination. So consider the following statements. Your statement number 1 is, according to the Constitution of India, a person can be disqualified if she has criminal records. And your statement number 2 is, according to the Representation of People Act 1951, a person convicted of criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. Which of the following statements given above are correct? Your options are: option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us understand a practice question for your mains examination. So the question is, and this is a PYQ that has been asked in the year 2013. So the question states that it is often said that politics and ethics do not go together. What is your opinion in this regard? Justify your answers with illustrations. So you can introduction, you can write that yes, politics and ethics have different values in them. Criminalization of politics is an issue which is not ethical. But you will also write that how criminalization of politics is affecting and what steps can you take to prevent criminalization of politics. You will write the initiatives, recommendations and what the Supreme Court has observed. And you will also give illustrations that even those candidates are winning the elections who do not have any pending criminal cases against them. So we are the people, by exercising our right to vote, can bring a change in this trend and can get rid of this menace. So you can write all of this and you will say that yes, it will take time. You can conclude holistically that it will take time, but small steps can help. And we should really exercise our right to vote very carefully because it is a very important power given in our hands. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.